I have prepared a few slides, so I will share my screen now. Excellent. Okay, so yes, like I said, thank you for that introduction. I will be talking today about the present and future of group action claims for underpaid and undervalued work. In terms of who pay justice are, I thought that might be a question in everyone's mind, so I thought I'd take some time to explain that. So as Ian has said, we are a workers' rights group who are formally registered as a claims management company regulated by the FCA, and we run a number of equal pay claims for undervalued and underpaid supermarket and retail employees. We were formed in 2012 out of an equal pay expert's frustration with the non-compliance and complacency in employers' equal pay law. And our goal is to make employment law as accessible as possible to those who need it but might feel like it's out of touch. And we work with some of the UK's leading employment lawyers to fight these equal pay cases on claimants' behalf. And our aim is to make it as simple and as easy as possible for supermarket and retail workers to fight for the higher, fairer pay that we believe that they deserve. So as all equal pay cases are, they are rooted in legislation, of course, and our legal partners specifically refer to the Equality Act of 2010 and reference work that is of equal value, so compare two roles that are of equal value. At this moment in time, we are currently running 9 equal pay claims consisting of Asda, Sainsbury's, Tesco, Morrison's, Co-op, Next, Boots, Wilko and TJX, which consists of TK Maxx and HomeSense. And our research states that the total number of employees affected across all of these employers exceeds over 500,000 people in the UK alone. Now, in terms of these equal pay claims, with the claims ongoing, they do relate to the premise that in-store colleagues, who statistically speaking are mainly women, are doing work that is of equal value to their comparators in the distribution centres, who again, statistically speaking, are mainly men. Now, whilst a supermarket cashier may not need as much physical strength demanded of a warehouse role, they are more likely to call on their resilience, diplomacy and communication skills while speaking to customers in store. Now, supermarket workers also have the added responsibilities of cash handling, food safety, and they're also subject to similar time pressures. And I know that we've had early discussions today about the role that supermarket workers have played within this COVID-19 crisis and how valuable we feel that their contributions are to this day. So whilst we believe that these two roles are of equal value to one another, surprisingly, in-store colleagues are paid up to £3 an hour less than their counterparts in the distribution centres. Now, unfortunately, in some retail roles, not all retail roles, but in some retail roles, the inequalities stretch far beyond just pay and also include the in-store colleagues not being offered or offered any at all benefits, such as enhanced overtime rates, Sunday and public holiday premiums, even rest breaks and uniform allowances are something that the in-store workers do miss out on as well. In terms of where paid justice comes in, we fight for the equal pay claims. So the equal pay claims are made in the difference between the in-store hourly rate of the in-store worker and the warehouse hourly rate. And we call that the back pay. So people are entitled to that difference in pay for every hour worked that they've worked historically. Now, under English law, that can go back up to 6 years, and in Scotland, that can go back up to 5 years. So that is the role that pay justice play with these claims, is fighting for those rights on behalf of these employees. So another question that I thought people may be wondering is, well, why to participate in group action claims? Why take part in a group action claim when there might be other ways to go about it? So I think Dame Moya Green touched on this slightly earlier, so I'll repeat that. But there are several features and benefits of these features of participating collectively in group action claims. The first of which is that the claims run by Pay Justice, in my experience, are done on a no-win, no-fee basis. So participating in an equal pay claim on an individual level, on a case-by-case basis, can be very costly and can be quite emotionally turbulent. In doing it through a group action claims, claimants are not asked to pay these fees up front, and there's low risk involved, as if the claim doesn't win, they have absolutely not a penny to pay. and there's less of an investment of time as well. Taking part in group action claims also means that these employees are joining tens of thousands of colleagues exactly like them in the exact same boat as them. So there's a great sense of unity and a degree of camaraderie, and that comes with these types of claims. Another benefit is that there's also a degree of anonymity when you're part of a very large group. It's very, very unlikely that someone's direct line manager or store manager, for example, knows that they are taking part in this large group action claim. Only if they, of course, choose to tell them, that's when they will know. Aside from this, there's quite a minimal effort required for a claimant to sign up to these claims. It's not as emotionally turbulent, like I was saying, and the sign-up process is relatively very quick and simple, and the lawyers do most of the work. And finally, another benefit to group action claims for lower paid workers is that they can seek a sense of comfort and security, knowing that there are anti-victimization laws in place that make it unlawful for your employer to treat you any differently or to make you lose your job for taking out unequal pay claim. So in terms of where we are now with these equal pay cases, it is important to understand that unfortunately they do take a very long time to conclude. And this is simply due to not only the length of time between the court proceedings, but as another speaker mentioned earlier on, the opposition's quite repetitive decision to appeal each decision that has been made. So as this diagram isn't quite illustrative of my point, but the Asda case, which is what I've highlighted in green, is the case that has been ongoing the longest because it started first and is leading the way for most of these employment cases. So this started back in the early 2013, I believe, and we are just about reaching the end of stage 1. Now, Asda workers actually won the first stage of this case on comparability back in 2016. However, Asda then appealed this decision on quite a few different grounds. So in 2017, the appeal tribunal ruled all of these grounds unsuccessful and again ruled in favour of the shop floor workers. And Asda have again requested to further appeal this judgment in the Supreme Court, a date of which for that hearing has not yet been set. So you can see that it's a very long process strung out by the employers themselves in order to elongate and make it an off-putting process, so less and less people join or in fact drop out of the claims. Whilst this is really frustrating for the claimants themselves, an added benefit to claimants involved is that if they still work at the supermarkets in which they are taking an equal pay case out of, their claim value does grow each day. So every day they are at work and being underpaid in comparison to their comparator, and every day that their employer prolongs the court proceedings is a day that they will be compensated for in the back pay that they are hoping to win. In terms of the future, we hope that a claim win will set a precedent for retail and supermarket pay scales across the board. And we hope that the existence of these equal pay claims will encourage employers now, in the present moment, to rethink their pay practices in the hope to avoid any legal action being taken in the future.
You start to wrap up, please, Alexia. Sure. Thank you.
And this precedent, we hope, will extend even further to other low-paid and undervalued sectors, such as cleaning, catering, clerical and care work, which I know we've also had discussions about earlier on in this session. If this is not the case, we do believe that the law must be enforced, and one way to do that is through legal action. So most large companies can just about tolerate bad press, but they can't ignore legal action. Thank you.